Hello everyone. Recently, a public interest litigation has been filed before the Supreme Court of India, in which the petitioner has asserted that the addition of the words secular and socialist in the preamble of the Constitution must be deleted because it was never the intention of the Constituent Assembly of India. So that's why this debate has again resurfaced that whether we should continue with the word secular and socialist as the part of the preamble. Now, in this particular case, in this particular petition, or on this particular hearing, the Supreme Court, while answering to the assertion of the petitioner, explained that as far as the word secular is concerned, in getting out judgments given by the Supreme Court of India, it has already been declared as a part of basic structure of the Constitution. And then Supreme Court also said that as far as the word socialist is concerned, we have devised our own variant of the word socialist, and we have not adopted any dictionary meaning which can be attributed to the word socialist. In fact, the Supreme Court in many landmark judgments, for example, Samantha versus State of Andhra Pradesh, Supreme Court made it clear that the word socialist in Indian Constitution implies establishment of an egalitarian order by rule of law. That is what is actually been defined by the Supreme Court in Samantha versus State of Andhra Pradesh. To which the petitioner argued that at least 3 times in the Constituent Assembly, 3 proposals were made for addition of the word secular and socialist in the Constitution of India. First such proposal was moved forward by the Professor of Law K.T. Shah, who was also the member of the Constituent Assembly, for addition of the word secular and socialist, but it was rejected by the Constituent Assembly after much deliberation and lengthy discussion. Second time and third time equally, this particular motion was forwarded for addition of the word secular and socialist, but again the Constituent Assembly rejected it. So that's why petitioner made it clear that when it was not the intention of the Constituent Assembly and was not incorporated originally in the Constitution, then why with the 42nd Amendment 1976 these 2 words have been added in the Constitution of India, in the preamble of the Constitution of India. Supreme Court also directed the petitioner to come with some arguments that whether addition of these 2 words in the preamble fall within the definition of amending power of the Parliament under Article 368 of the Constitution of India. So let's see the Supreme Court in the next hearing, how Supreme Court proceed and decide this particular case. This will be again a very important and landmark judgment given by the Supreme Court of India. So from this discussion, the key takeaways for us is, first, secularism has already been declared part of basic structure. Name of the case is S.R. Bhumik versus Union of India. Second, Samantha versus State of Andhra Pradesh, in which the Supreme Court, while defining the socialist, said that it amounts to establishment of the egalitarian social order with the help of rule of law. Moreover, third important point is that even Dr. Ambedkar rejected the idea of incorporating the word secular and socialist in the preamble, and that is quite evident from the debates of the Constituent Assembly. Dr. Ambedkar, while explaining it, said that any social and economic order of the society must be decided by the citizens. You cannot thrust upon the citizens such kind of political ideologies like secular or socialist.